Hello everybody, welcome to JURIScenter.com online classes for law exams. So I will be dealing with you today the most important judgments given by the Supreme Court, and it is for month June 2021. So let us see the judgments, and I will be dealing with you only the important ones. So let us see. So the first case is Sheikh Ahmed versus State of Telangana, decided on 28th of June 2021. In this, it has been held by the Supreme Court that no conviction under section 364A IPC if kidnapper treats victim in a good manner. So let us see the facts first. The court was dealing with a case wherein a 13-year-old boy was kidnapped for ransom by a driver of an auto that the child had hired to go home from his school. The accused, who was driving the said auto, took the child to the house of his sister and demanded a ransom of rupees 2 lakhs from the child's father. After receiving the phone call, the child's father went to the police station and lodged a report. The accused was apprehended by the police while the child's father was trying to hand over the ransom to the accused. The child was found in an auto a short distance away. In this case, essential ingredients was laid down by the Supreme Court under section 364A to implicate or to convict a person under section 364A. Certain essential ingredients has been laid down. Let us see. The bench of Ashok Bhushan and R. Subhash Reddy justices has laid down the essential ingredients required to be proved by prosecution to convict an accused under section 364A IPC, that is kidnapping for ransom. So section 364A of IPC deals with kidnapping for ransom. The essential ingredients are kidnapping or abduction of any person or keeping a person in detention after such kidnapping or abduction, and threatens to cause death or hurt to such person or by his conduct gives rise to a reasonable apprehension that such person may be put to death or hurt, or third, causes hurt or death to such person in order to compel the government or any foreign state or any governmental organization or any other person to do or abstain from doing any act or to pay a ransom. So the court explained that after establishing first condition, one more condition has to be fulfilled. Since after first condition word used is and, thus in addition to the first condition, either condition 2 or 3 has to be proved, failing which conviction under section 364A cannot be sustained. So the first clause of essential ingredients have to be satisfied, and later on any any of the two clauses, that is 2 or 3, need to be satisfied, and failing which the conviction under section 364A cannot be sustained. Child was treated in a good manner. It is important to note that as per the statement of the child, he had himself stated he was treated in a good manner. He had also not alleged that any threat was extended to cause death or hurt to the victim. In such circumstances, the second condition highlighted above, which is and threatens to cause a death or hurt to such person or by his conduct, gives rise to a reasonable apprehension that such person may be put to death or hurt, stood unfulfilled. The court has set aside the conviction of the appellant under section 364A as the child was not kept under instant threat or death. Then the next one, very important judgment. I have already covered it in one of the editorial while I was discussing the most important editorial passages for your upcoming CLAT PG. So let us see the case law again. The case citation is Deepak Kansal versus Union of India, decided on 30th of June 2021. In this, Supreme Court has said that NDMA to come up with uniform guidelines for ex gratia assistance on account of lives lost due to COVID-19 within 6 weeks. So this is the order given by the Supreme Court, and here are the direction issued by the court. First is National Disaster Management Authority to recommend guidelines for ex gratia assistance on account of loss of life to the family members of the persons who died due to COVID-19 as mandated under section 12 clause 3 of DMA Disaster Management Act 2005 for the minimum standards of relief to be provided to the person affected by disaster COVID-19 pandemic over and above the guidelines already recommended for the minimum standards of relief to be provided to persons affected by COVID-19. So in this case, the Supreme Court has given the direction to the NDMA to frame a guideline for compensating the victims of COVID-19. Then, however, what reasonable amount to be offered towards ex gratia assistance is left to the wisdom of the national authority. In this case, court hasn't decided any ex gratia amount. The appropriate authority is directed to issue simplified guidelines for issuance of death certificates, official document stating the exact cause of death due to COVID-19 to the family members of the deceased who died due to COVID-19. So in this case, the appropriate authority has been directed for issuance of death certificates relating to the patients who have died due to COVID-19. Then the next one, very important, in this one nation, one ration card scheme has to be implemented by July 31st, has been directed by or has been ordered by Supreme Court. In the case of in re, this is a suo motu case. In re, problems and miseries of migrant laborers, suo motu, repetition, civil number so and so. It is decided on 29th of June 2021. The bench of Ashok Bhushan and M.R. Shah justices has issued extensive directions to ensure the welfare of the migrant laborers who have been severely affected due to the outbreak of the COVID-19 pandemic. Hence, in order to ensure the unorganized migrant laborers have access to at least bare necessities of life, the court issued the following directions. So, these directions have been issued to secure the bare necessities of the unorganized or migrant laborers. So, first one is portal for registration of the unorganized laborers, migrant workers. The central government as well as the respective states and the union territories to complete the process of portal for registration under National Database for Unorganized Workers, which will be known as NDUW project, as well as implement the same by which by all means may commence not later than 31st of July 2021. Second, states to bring in place an appropriate scheme for distribution of dry ration to migrant laborers, for which it shall be open for states to ask for allocation of additional food grains from the central government. And third, the states who have not yet implemented one nation, one ration card scheme are directed to implement the same by not later than 31st of July 2021. So by 31st of July 2021, it has been directed that the registration has to be completed of the unorganized laborers or migrant workers. Then a dry ration has to be distributed among the unorganized workers, and also one nation and one ration card has to be implemented not later than 31st of July 2021. Then next one is, in this case, Supreme Court states Delhi High Court's order holding IGST on personal oxygen concentrators, which it has termed as unconstitutional. So the citation is Ministry of Finance versus Gulsharan Singh. So let us see, the bench of Dr. D.Y. Chandrachud and M.R. Shah justices has stayed the Delhi High Court's order holding the levy of IGST on oxygen concentrators imported as gifts for personal use, violative of Articles 14 and 21 of the Constitution. So earlier Delhi High Court has actually held the order of imposing IGST, that means the taxes, the GST taxes on the personal oxygen concentrators, as violative of Article 14 and 21. Delhi High Court had called oxygen shortage a George Floyd moment for the citizens. There is a famous song of George Floyd known as I Can't Breathe. So it has quoted that song of George Floyd in this judgment and held the imposition of IGST on oxygen concentrators imported by individuals unconstitutional. Then next one is cancellation of class 12 board exams. CBSE ICSE assessment schemes fair, reasonable and in larger public interest. It has been held by the Supreme Court in the case of Mamta Sharma versus CBSE. So in this, certain group of students have challenged the cancellation of class 12 board exams and also the internal assessment procedure for evaluation of the result. That the record, the marks has to be taken for the last 3 years of a student for for calculating the same. Then the bench of A.M. Khanwilkar and Dinesh Maheshwari justices has refused to interfere with the assessment scheme propounded by the CBSE or ICSE of the class 12 student and has held that the stated schemes are fair and reasonable and take into account concerns of all students and is in larger public interest. Then the next one is children orphaned by COVID-19. No illegal adoption, no discontinuance of education. Supreme Court issued directions. In the case of indirect contagion of COVID-19 virus in children protection homes, which has been decided on 7th of June 2021, very important judgment. So let us see, considering the need for continuous monitoring of the implementation of the schemes in favor of the affected children, the bench of L. Nageshwara Rao and Aniruddha Bose, JJ, has issued a series of directions after it was submitted before it by amicus curiae Gaurav Agarwal that identification of children who have become orphans or have lost one of their parents during this pandemic doesn't brook any delay. Immediate relief should follow the identification of such children without any delay. So court has given the directions in the welfare of such children who have lost their parents in the COVID-19. So see what are the directions. So first of all, we'll see the data. The information provided by the state governments, union territories on the Bal Swaraj portal up to 5th of June 2021 shows that there are 30,071 children who have become orphans or have lost one parent or abandoned. There are 3,621 orphans to 26,176 children have lost one parent and 274 children have been abandoned. So these are the number of affected children. Illegal adoption of affected children, what the Supreme Court has said regarding to that. It says the state government union territories are directed to prevent any NGO from collecting funds in the names of the affected children by disclosing their identity and inviting interested persons to adopt them. No adoption of affected children should be permitted contrary to the provisions of the JJ Act 2015. So in this case, Supreme Court says that illegal adoption of the affected children of COVID-19 shall not be done, and it also says that children cannot be permitted to be adopted without following the provisions of the JJ Act, that is Juvenile Justice Act 2015. An invitation to persons for adoption of orphans is contrary to law, as no adoption of a child can be permitted without the involvement of CARA. Then the directions, the state governments, union territories are directed to continue identifying the children who have become orphans or lost a parent after March 2020 either due to COVID-19 or otherwise. So a duty has been given to state governments or union territories to identify the children who have become orphans due to the COVID-19 pandemic. The DCPU should ensure that adequate provisions are made for ration, food, medicine, clothing, etc. for the affected child. Financial assistance to which the disconsolate child is entitled to under the prevailing schemes by the central government and the state government union territories should be provided without any delay. So by the Supreme Court is also directing the DCPU to provide ration, food, medicine to the affected children and also the financial assistance to the children according to the schemes provided by the central government or the state government. The state government union territories are directed to make provisions for continuance of education of the children both in government as well as in private schools. Even education facility has also to be provided to the affected child both in public as well as private schools. Then the state government union territories are directed to take action against those NGOs, individuals who are indulging in illegal adoptions. Then the next one is, this case is also very important. This relating to cruelty and dowry death. The question is, can conviction under section 304B IPC sustain without any charges under section 498A IPC? So this is the issue raised before the Supreme Court in the case of Gurmeet Singh versus State of Punjab, decided on 28th of May 2021. So with the judgments decided in June, I am also discussing, few judgments I will be discussing with you which have been decided in the previous month, that is on May. So let us see the background first. The deceased got married to the accused in November 2004 and gave birth to child in 2006. The death of the accused occurred in 2008 after she consumed poison in her matrimonial home. Both the trial court and the Punjab and Haryana High Court convicted the husband under section 304B for dowry death. It was argued that without any charges under section 498 IPC, a conviction under section 304B IPC cannot be sustained. So let us see the analysis first. Section 304B IPC defines dowry death of a woman. So it says that dowry death shall be caused within 7 years of marriage, and only if it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband in connection with demand for dowry. Considering the aforementioned said law, the court noted that since the marriage between the deceased and the accused appellant took place on 23rd of November 2004 and the death of the deceased occurred in 2008 after she consumed poison in her matrimonial home, therefore the first two ingredients as to death under otherwise the normal circumstances within 7 years of marriage stands satisfied. So this condition is standing satisfied. Next one is coming to the next ingredient necessary for establishing the existence of dowry demand, that is soon before her death. The court noticed that the deceased had expressed her unhappiness due to the constant harassment and dowry demands to her father. The father also stated as to how the families attempted to mediate the dispute themselves, and on multiple occasions the father of deceased gave certain gifts to the accused and his family to ameliorate the situation. Also further, the mother of the deceased had informed the father 15 to 20 days prior to the incident about the continuing harassment of the deceased on account of dowry. Then finally, on 8th of August 2008, the father-in-law of the deceased informed this witness about the consumption of poison by the deceased. It was hence concluded that necessary ingredients under section 304B IPC stood satisfied as the death takes place soon. As the woman was subjected to cruelty soon before her death, because there was because she was harassed for dowry by her in-laws, and that happened in a span of 15 to 20 days prior to her death. So in this case, a distinction has also been made between section 498 and 304B. Let us see. The three-judge bench of N.V. Ramana, Chief Justice of India, and Surya Kant and Aniruddha Bose, Justices, has rejected the contention and has explained all the cruelty is a common thread existing in both the offences. However, the ingredients of each offence are distinct and must be proved separately by the prosecution. If a case is made out, there can be conviction under both the sections. So by this, the Supreme Court wants to say that even if that person is not booked under section 498A, that person can also be prosecuted and convicted under section 304B, as there is a distinction between section 498A and 304B. Then the next one is, when can proviso clause 6, subsection 6 of section 92 of Evidence Act 1872 be invoked? So this issue has been raised before the Supreme Court in the case of Mangala woman Krandikar versus Prakash Damodar Ranade, decided on 7th of May 2021. So these two cases, the previous one and this one, have been the most important case laws of the month of May. So let us see. Explaining the scope of section 92 proviso 6 of the Evidence Act 1872, the three-judge bench of N.V. Ramana, Chief Justice, and Surya Kant and Aniruddha Bose, Justices, has held that the said proviso can be resorted to. That means the proviso section 6 of section 92 to only in cases where the terms of the document leave the question in doubt. But when a document is a straightforward one and presents no difficulty in construing it, the proviso doesn't apply. In this regard, we must state that Section 95 only builds on the proviso Section 6 of Section 92. So this is the end of the session, and I hope you all have enjoyed it. Do not forget to give a like, share and subscribe to the channel. Till we meet the next time. Thank you. Have a nice day.